Hello, everyone. Today we are together with three distinguished guests. We will discuss about the sanctions and the export control compliance policies. And as we will also talk about the Turkey as a country which has not joined its fellow NATO members in imposing sanctions on Russia. And since the start of the invasion of Ukraine, there are many entities have been subject of the Western sanctions themselves for supplying to Russia with goods and that have aided its war efforts. And we have Tom, we have Harry, and we have Craig today. I will leave the stage and Tom to continue the presentation.
Thank you very much, Suffolk. And it's great to be with you all this evening. And thanks for joining us. We're looking forward to sharing some thoughts, ideas, and information, basically an introduction to U.S. export controls. I am, let me introduce myself and then I'll turn it over to my partners. I'm Tom Androkonis, and I'm with Export Control and Sanctions Advisors, which is an export control advisor group in the United States. Previous to that, I worked with another consulting company. And before that, for a little over 40 years with the U.S. Commerce Department, Bureau of Industry and Security, on both the export enforcement and the export administration or licensing and compliance sides of the house there. I'm very fortunate to have two esteemed colleagues with me, Harry Clark, senior partner at ORC, Harrington and Sutcliffe, who I'll let talk a little about himself, and then Craig Fildius as well.
Sure. It's a real pleasure to participate in this important program. I'm Harry Clark. As Tom said, I'm with the law firm Ork, Harrington, and Sutcliffe. We are proud founding sponsors of the broader Sanctions and Export Control Society's initiative. We could not be more pleased with the founding of the Turkish chapter of the initiative. I've been working on sanctions and export control issues since I began practicing in 1989, and this is one of the more exciting ventures in which I've ever participated in my professional life. So it's a pleasure to join you today. Craig?
Yeah, good evening, everybody. Again, as Tom said, Craig Fildius. I just retired from 28 and a half years with the U.S. government, 12 of which I spent with the U.S. Department of Commerce, Bureau of Industry and Security. And my last posting was actually in Istanbul, Turkey. I was there for 5 years, a little bit over 5 years. And I left kicking and screaming. Really, really enjoyed the country and working there and working with all the wonderful Turkish people. So, like I said, I retired last Friday. So I don't even know if I'm associated. I'm a free agent, if you will. I'm just a retired guy and finding my way after all this time working for the government. So, but happy to be here today, and hopefully I will be able to impart some some words of wisdom, having worked in Turkey and in that region, and give you, share some of the experiences that I had.
Thanks, Craig. Thanks, Harry. And Craig, you've got at least 30, 40 more years to work, so don't worry. We'll have plenty to do. So let's start with just giving kind of a broad overview, if you will, of kind of United States dual-use export controls, which are the ones that, in most cases, we'll talk about each of the primary export control and licensing agencies of the U.S. government, but the U.S. dual-use controls are the ones that have the highest level of license applications or licenses issued and activity relative to kind of civilian trade across, global borders. So let's start by kind of looking at that. And certainly the idea is to restrict or control exports, even re-exports from one country to another, or even in-country transfers of certain items, goods, software, technology that are either U.S. origin or have a certain content of U.S. Controlled items. Certainly, the purpose that the U.S. government would tell you is to promote U.S. national security, foreign policy, and in some cases, economic goals of the United States. And now, what activities can the U.S. export controls apply to? As you kind of see here, any export of actual shipments from the United States, that can even be a foreign item that happens to come into the United States. Once in the United States proper, all of the export controls are subject to that item as they leave now the United States. And then, of course, U.S. origin items that are controlled that are in the United States or abroad that are now being resold to another party, or even an in-country transfer or change in an end use of one type of activity for the item to be used for to another, could subject it to U.S. export controls as well. They are very broad, and we'll go into some of those kind of details of how they can come into place. And then finally, maybe a weird terminology, deemed exports is what the Export Administration Regulations refers to them as. And a deemed export, it refers to basically a transfer of know-how or technology or information from one party to the next, which can be in a variety of different ways, just speaking, transferring intellectual property from a U.S. Party to a foreign party who's in the United States. So if a U.S. company, let's say, hired a national from India, and that Indian national needed to have access to technology to do his or her job that was very sensitive and controlled by the Export Administration Regulations, that would be deemed an export to India, even though that Indian national would be somewhere in the United States having access to that technology. And that's what they refer to as a deemed export. A deemed re-export, very similar, but just it's done overseas. So let's say if that U.S. company had a plant in India, and they were going to transfer that U.S. technology in India to another foreign national there, but that person, to enable them to do their job overseas in India, that would be deemed re-export. And either of those could require an authorization or license prior to that transfer, depending on the control level of kind of those technologies involved. So as you can see, kind of in an overview, there's a lot of things that these regulations can end up controlling.
And Tom, I would reinforce what you're saying, that it is a bit of a remarkable proposition that transactions and activities occurring in Turkey can be covered by these U.S. requirements. And understandably, many find that at minimum irritating and perhaps even offensive, but it doesn't change the reality that the U.S. government considers that they apply extraterritorially, the way Tom's describing, and in fact enforces them on that basis. So it can, the result can be meaningful penalties and other downsides for not taking these requirements seriously.
Yeah, and Harry raises a great point, because over the course of our careers, both of ours starting in the 1980s, we're both familiar with incentives from countries in the EU and elsewhere to kind of, manufacture out U.S. origin items just because of the pain in the neck, if you will, of some of these extraterritorial kind of controls of having certain parts or components in an overall manufacturing process or an end item that may have attached to them these kind of either export controls or sanctions issues related to dealing with that. And so to some degree, the U.S. government over the several decades has tried to create either license exceptions or other regulatory changes to try to ease that that notion, to hopefully help people not to kind of manufacture out and continue, good global trade across the world here. So just kind of continuing, if you will, as we kind of already mentioned, first it starts with the U.S. Congress. There has to be a law first, and finally, after many, many years of dealing under the International Emergency Powers Act, U.S. Congress passed in 2018 the Export Control Reform Act, which kind of formalized and permanently placed that legislation in place for then the Commerce Department's Bureau of Industry and Security to have under promulgated their regulations, the Export Administration Regulations, or the EAR, to be then enacted, administered, enforced by the Commerce Department's Bureau of Industry and Security, among other enforcement agencies as well, which we'll talk about a little bit more. Now, the Bureau of Industry and Security, where Craig and I, worked at some point, is in charge of administering, which is a big word that basically means everything from kind of updating those regulations to doing outreach and training to issuing licenses, commodity classifications, compliance activities and work, active enforcement, investigations, administratively and criminally, and working with other enforcement organizations as well, and different agencies as they do, administer those export administration regulations. You'll hear the term dual use referred to a lot, and predominantly, overwhelming majority of the export administration regulations deals with dual use items, meaning they could be used and predominantly used for civilian purposes, but they could be used for military activities too. Now, a few years back under the Obama administration, under export control reform, that administration moved some of the items controlled by the State Department, which controls military items useful in military activities, from the State Department in the United States over to the Commerce Department. So there are some items that have more direct military end uses that have been moved over to the Bureau of Industry and Security from the State Department around the 2016 timeframe in that regard. And the Department of Justice, as it's mentioned here, is certainly a big player for any criminal investigation or prosecution. The Commerce Department's Office of Export Enforcement will work with those assistant U.S. attorneys to prosecute in U.S. courts any criminal activities. Administratively, we'll talk about as well. There are administrative remedies too that the Bureau of Industry and Security can put into place here. And certainly, as the final note there says, and it is true, the Department of Justice has really expanded. They've added a number of attorneys to specifically the National Security Division to prosecute these types of export control violations. And there's been a joint task force formed between Bureau's Office of Export Enforcement and the Department of Justice to even increase the collaboration and coordination and success of different kinds of investigations and prosecutions over the last year. So talking a little bit about kind of something Harry mentioned too, is kind of the extraterritorial nature of U.S. export control laws, which is true. And then you think about it a little bit, when you see that word multilateral versus unilateral, hopefully it's kind of understandable, but multilateral meaning that a lot of these organizations that are in the bullets here are ones that are associated and attended by several different countries around the world that see eye to eye on those list of items that should be controlled to protect either nuclear non-proliferation, chemical and biological weapons uses. The Wassenaar arrangement, which it was kind of the largest, if you will, that was preceded by COCOM back in the days when Harry and I started. That then became Wassenaar. COCOM obviously had a direction against, at that point, the Eastern Bloc, if you will, and the Soviet Union. Now the Russian Federation is a member of Wassenaar arrangement that meets in Vienna, Austria. And so all of those agreements there, those groups, would have organizations and countries that agreed to a multilateral list of items that are controlled and that they must license. And they have some certain parameters too, where they share information and coordinate. If somebody's going to, deny something, they may share that information with other members so they know if somebody's going to shop for that item, to kind of be aware and raise it before, maybe another member approves it. And unilateral controls, as they sound, are ones predominantly or often on the U.S. side, where there are certain items that they believe still are useful for certain end uses or by end users that could be used in a very negative way that would impact global security, international security, and even foreign policy interests of the United States. So there is anti-terrorism controls on certain items and short supply controls on certain very strategic items, which is a shorter list today, that were created and added to the list a little over 20 years ago now at this point in time. But those are unilateral controls, and I'll help you and go through some of the numbers so you can identify what is a unilateral controlled item versus a multilateral controlled item. Now here, and I love this slide because in one place, you really have all of the main three licensing agencies of the U.S. government. You have the Department of State, the Directorate of Defense Controls, the agency there, the Department of Commerce, Bureau of Industry and Security, and the Department of Treasury, Office of Foreign Assets Control, or often referred to as OFAC. Those are the three main U.S. export control licensing agencies. And then, as I said before, it's very important and critical and necessary for the U.S. Congress to pass legislation or laws for each of those agencies to then enact with regulations to then administer and enforce. And there's the regulation in the third column for each of those three laws associated with those agencies that have been put in place for them to then administer and enforce. And then finally, over on the right, it gives you the scope of what types of items or activities that each three of those agencies or the regulations and the laws associated with that agency are involved in. So really in one slide, it gives you a lot of very detailed information about who's who on kind of the U.S. export control landscape, if you will. I think I've got just a couple slides here. I'll go through kind of quickly because we've all seen kind of these before, but I think just so you have it, and we can make these slides available to you, the mission statement of each of those three agencies, which is not surprising, that you see kind of like from Commerce, Bureau of Industry and Security, is to advance U.S. national security and foreign policy, economic objectives, ensuring export control and treaty compliance system, and promoting U.S. strategic technology leadership. And the Export Administration regulations, often referred to as just the EAR, are those regulations that they administer and enforce at the Commerce Department's Bureau of Industry and Security. The second one is the U.S. Department of State, the Directorate of Defense Trade Controls, also there in Washington. And they're looking at commercial exports of defense articles and services, defense services, to advance U.S. national security and foreign policy interests. And the International Traffic in Arms Regulations, or the ITAR, are the regulations that Department of State, DDTC, is going to be enforcing. And then finally is the U.S. Department of Treasury, or OFAC, Foreign Assets Control. And they're dealing really with more the economic and the trade sanctions that the U.S. has put into place based on either foreign policy or national security goals, targeting certain countries or players, individuals, organizations that are active in either international narcotics, terrorism, WMD proliferation, et cetera. And their charter goes back to the Trading with the Enemy Act over 100 years back. And OFAC does have separate branches that handles kind of the licensing and the enforcement or the compliance activities within it as they administer their regulations. So let's go on a little bit a kind of the Export Administration and dual use controls kind of generally, if I can use that term. The important term you hear often is an item subject to the Export Administration regulations? And subject to is very important to first identify if those regulations apply to that particular commodity or software, technology or activity, or that U.S. person involved even as well, because that kind of determination is important first to then decide what is necessary next. Is it an item originate as an export from the United States? Is it a U.S. controlled item that's now being resold or re-exported to another party or sold to somebody else? Is the percentage of the U.S. controlled content of a certain percentage de minimis levels that now subjects it to the Export Administration regulations, and that can either be 25% worldwide, or 10% if you're dealing with embargoed destinations. And then the other list that's very important is the CCL, or the Commerce Control List, and that is a positive list of all the items that the Commerce's Bureau of Industry and Security controls and license and requires licenses for. And then within that list, you'll have export control classification numbers, or ECCNs. And the way I think it's easiest to describe that export control classification number is to read it backwards. It's a number that classifies and then controls that export. So it's an easy way to understand what that specific individual export control classification number does and why is it relevant. And on the commerce list, they've done their best to make it a very positive list, and by that meaning identifying specific parameters of each of the items on that commerce control list of why they would be captured, caught under that ECCN or not. If an item isn't on the commerce control list, then there's a catch-all category referred to as EAR 99, meaning it's subject to the Export Administration regulations. So I got to think about that. It's subject now, but it's not captured in any of the specific export control classification numbers. And I'll explain the importance of that here in a minute as we go through an example of one of the ECCNs.
And just, Tom, to reinforce a really crucial element of your of this slide, and I think it may be a bit counterintuitive to many, that by and large, when someone is trying to decide, hey, do U.S. export controls, could they restrict this transaction? By and large, that question is not the answer to that question is not driven by who is acting. Is it a U.S. company? Are there U.S. people, U.S. citizens involved? There are exceptions, but by and large, none of that matters. It could be anybody, anywhere acting. What generally matters is the item that's being transferred. Whether it's equipment or software or technical know-how, was that item, and I know we'll speak more about this, but was that item originate in the United States, or is it connected to the United States in certain other ways? And that's what really drives the outcome, the status of the item and its connections to the United States. Go ahead, Tom.
Great. No, thanks, Harry. That's a great point. Thanks. And I think, often people refer to lists and you kind of want to see, okay, what all is on that list? Well, here are the 10 categories on the Commerce Control List. And as you can kind of see, they're lumped from 0 to 9 in different areas: nuclear, materials, chemicals, materials processing, electronics, computers, sensors, across the board. And these kind of mirror the EU list, if you will, in Wassenaar to a large degree, that the Wassenaar and the multilateral control members of those 42 countries all have very similar types of categories on their dual use list as well. But I think it's helpful, to me at least it was, to actually look at an example of an export control classification number, because that number in itself can tell you a lot of stuff about that item and the control of it. So as you can see, it's an alphanumeric number, and it's each field identifies something that's critical or important. The first digit, the number there, 3, identifies the category on the commerce control list. And in this case, 3, if we go back to it, we can say, 3, we're dealing with something that's electronics. So we know right off the bat, and I see 3A001, I know I'm dealing with electronics. It's like, okay, well, what kind of animal is this? I see the product group is A. And A, I look over at the product group list, it's very obvious that this is some kind of piece of equipment or an assembly or possibly a component. And you can see the other product groups, if the letter happened to be different in the category B, that's tester inspection equipment for the same kind of electronic stuff. And if it's C, it's just materials that make it up. The D is for software related to that category 3. And E would be technical know-how or technology related to 3 in the electronics field. So I know it's 3 electronics. I know the product group is A, so it's an overall big equipment. The third digit is very important because that third one is the reason for control. And as you can see over in that right column, because there's a 0 there, I know that this is controlled for national security purposes. So that's pretty important. Now, items can have multiple reasons for control too. So keep that in mind, and I'll show you, I have a list next with all the various reasons for control, and I'll show you the country chart. But so that third digit's important because that helps you identify if you need a license or not when we go to the country chart, the reason for control. And then that fourth digit there is the either identifies if it's unilateral control only by that one country, or is it multilateral controlled if it's a 0 through 8 by the Wassenaar group. So in this case, it's a 0, so we know it is multilateral controlled, not unilateral, which would be a much lesser control as far as the export control of that matter. And then the fifth and final digit is just a sequential numbering. So as you can see, an export control classification number gives you a lot of information about what you're dealing with and what kinds of things I might need to worry about as far as the license requirement, as Harry pointed out, is probably the most important and first step in any sales or transaction is what am I dealing with? What are the facts on hand that I have to first make determinations, the second, who's then buying it from there. But as promised, I said I would give you a slide with all the reasons for control, and I know there's several here. The AT, and just in alphabetical order, those are those unilateral controls. So those are going to be ones that are just controlled from that standpoint only for that one country, the U.S. in this case, for anti-terrorism reasons. But you've got chemical, biological, encryption controls, missile technology, national security, and in some cases, crime control. You can have multiple columns. So like for national security, when we go to the country chart, there'll be national security column 1 and national security column 2 items with the differentiation as far as the reason for control. And when you go to the commerce control list and you look up that item, you can identify what's the specific reason. And sometimes it may be cut as part of that 3A001, like certain subparts, subparagraphs, they'll refer to them, are controlled for certain reasons and other subparagraphs for others. So it's very important to identify that reason for control, because the next step in the whole equation is once you identify the export control classification number for the item involved, is going to the commerce country chart. And if there's an X in that box for that country you're dealing with, let's say Armenia here, we've got Armenia, and let's say I have a national security item. I go over to that middle column for national security and you see NS1, NS2. They actually differentiated, as I said, some with multiple columns. as they do for chemical, biological, and nuclear proliferation and crime control as well. So in Armenia, I see if I have a 3A001 item that's controlled for national security reasons, there's an X in both boxes, NS1 and NS2. So I know I need a license for that item to be shipped to that Armenian customer in this case. Now, where that may be true, you got to keep in mind there may be, some, situations where maybe there's an exception, and I'll get to that in a minute. But again, the four facts on hand that are most important, as Harry pointed out, is identifying that export control classification number, ECCN, and I got to know what country I'm going to, so I can go to that country chart and identify it. And then I need to think about, all right, now who's the end user in Armenia? And as we'll talk about later, there's a whole bunch of lists of prescribed parties where there may be additional license requirements, restrictions, or even not allowed to certain parties, maybe in that country I'm selling it to. And then what's the end use? Are they using it for typical civilian types of end uses that they've identified to me? Or are they putting it in something that, the government is not going to approve a license for? So those four facts on hand are very important to make that decision as far as the license requirement for a U.S. origin controlled item that's being shipped, let's say from Turkey now to Armenia in this example that I'm talking about. There is a lot of discretion involved in the kind of the license process, if you will, based on the current foreign policy, national security concerns at that point in time. The average processing time now, I think the last I saw for the last year they published was 2021, is something like, was about like 40, almost 38 to 40 days, calendar days to process. And that's an average. That means some may be a little quicker, a lot longer. That can actually take several months. There is an appeal process. If you do get an intent to deny letter, or that the Bureau of Industry and Security intends to deny it, or actually does finally deny it, there are appeal processes to move forward. And it says, as it says here, generally all exports of items subject to the Export Administration regulations, including the basket category EAR 99 items to a sanctioned country or territory, are prohibited absent a license or exception. So, and even in some cases, U.S. persons can be involved or, have additional requirements. So we found an X in the box for national security items to Armenia in our example. So do I need a license? Probably, but there could be a license exception. And similar on the EU side, they refer to them slightly differently, but in certain instances, because either the item, the end user, or the destination, or other factors involved, maybe a temporary export that's going for a demonstration and coming back to Turkey, or a number of different varieties, there are license exceptions that might apply for me to transfer that item from the US to Turkey, or from Turkey to Armenia in that example. So it's important to at least be knowledgeable of that and check it. There are some restrictions, as the slide here says, that thou shalt not use license exceptions in certain cases and for certain items because they're just more sensitive, encryption among other items. There are also, in certain cases, even for a license exception where you don't have to apply and send anything into the government, certain steps that you may have to take. You may need to get like in certain license exceptions, some statement from that customer first before you re-export that item to them. So it's important to make sure you understand the parameters of that license exception if you are going to use it and if it does apply. Let's see, going forward. Here's a fun topic that nobody likes, and we kind of hit on this before, and it's kind of the extraterritorial nature of export controls in general, because the law follows that item or that U.S. origin item, depending on the content and the control level, and ultimately the destination and user, et cetera. So all of those things can come into play when you talk about U.S. export controls and complying with them. It is a very frustrating for many, and can be, it's broadly applied even outside the United States. So any U.S. origin item, wherever located, So remember, if I even have a pretty low level EAR 99 item, and I'm sitting in Turkey, but it's U.S. origin, and I bought it, and now I'm going to sell it to some country that maybe for that U.S. export control has higher, requirements. I'm going to send this to North Korea. I don't think so. Am I going to send this to Iran? I don't think so. Can I send it to Russia? Maybe, maybe not. There's obviously much stronger or stringent controls by the U.S. and other partner countries right now relative to Russia. So all of those things come into play, as well as the percentage of the de minimis content of U.S. origin within that item. So there are some parameters to take into place when you start thinking of kind of compliance and extraterritorial. And then this foreign direct product rule, which may kind of, seem complex, and it is to some degree. The idea here, and it started, really just with one foreign direct product rule, and now there are not as many as 9 foreign direct product rules, is basically saying even if you used all foreign origin items, if that product was initiated with U.S. technology in the plant or the know-how, intellectual property to produce that item with all foreign parts, we're going to control that in certain situations. And as you can see, those situations are relative mostly to U.S. foreign policy and national security concerns and interests. One's now to Russia, foreign direct product rules to Iran, foreign direct product rules to listed entities like Huawei and others that they've seen activities by those parties that gives the U.S. pause of concern. So if that foreign produced product is, there's U.S. technology involved in producing that with all foreign parts, in those certain 9 cases, the foreign direct product rule can kick into play and has caused some multi-global companies additional resources to kind of figure out, when and if it does apply to them in certain cases. So it's an important kind of rule to think about. And as well, now there have been expansions of controls on U.S. persons in addition. And I think Harry has some more, I think he'd share on kind of some of the economic sanctions relative to extraterritoriality as well.
Will do, Tom. Can you back up one slide? I just want to once more, I'm a bit of a broken record here, but I guess I in particular have been using this sort of esoteric term extraterritorial. And what we're talking about is the fact of the U.S. rules applying to a Turkish company acting in Turkey. And just to highlight what Tom was saying here, yes, how could that be? Why would that be? When would that be? Well, the key, again, as we keep saying, is it's all about the item. It does, it's a Turkish company, not a U.S. company. The activities occurring in Turkey, not in the United States, but the item originated in the United States, an item being equipment or software or technical know-how. The item originated in the United States, or as the slide shows, it's connected to the United States in certain other ways. And if the item satisfies any of these requirements, the U.S. government says, I don't care that it's a Turkish company. I don't care that it's acting in Turkey. We still regulate that transaction. Great, Tom, and maybe you can advance it one slide.
Sure.
And I will switch gears and now talking about economic sanctions. And these are fundamentally different in how they apply to activity outside the United States. As Tom indicated before, sanctions, we're not talking about export controls, we're talking about sanctions here, and they're related but different. Whereas the export controls typically, not always, but typically apply to a relatively narrow band of items. but they can apply all over the world. With the sanctions, they can apply to virtually any type of transaction. It's not just exports of certain items, but they generally only restrict transactions in certain parts of the world or relating to certain sanctioned parties. And they generally depend. Now, we're not talking about the item determining whether these U.S. restrictions apply, but normally talking about whether there is a U.S. company or a U.S. citizen or sometimes a U.S. controlled company involved. That's how the sanctions apply extraterritorially. And particularly with respect to Iran, the United States embargoes virtually all business with or relating to Iran. And so this is something for Turkish companies to keep very much in mind. It's generally, of course, perfectly lawful for Turkish companies to engage in business with Iran. But if there is some connection to the United States, if there's a U.S. Company involved in the transaction or a U.S. citizen involved in the transaction, or for Iran, a U.S. controlled company involved, then there could be a problem under the U.S. sanctions, the U.S. embargo of Iran. So just something to, and Syria for that matter. I've been focusing on Iran, but Syria is also embargoed by the United States. In addition, other countries, Cuba, North Korea, parts of Ukraine.
Thanks, Harry. Yeah, that's good. And that's a difficult sometimes thing to kind of understand. I agree. It makes it a lot of fun. I want to talk a little bit now, just switch gears to some degree on some of these trade restriction lists and examples that each of the agencies we talked about at the beginning of U.S. export controls, Commerce, State, and Treasury have. I won't spend a lot of time on them because, but the main thing is to understand there's been a proliferation or additions of new lists, new kinds of lists, military end users, unverified lists, in addition to the original standby the denied persons lists and now entity list at the Commerce Department. If you total them all up, there's over, I think, 20,000 parties on all of these U.S. lists. So it's important to just be cognizant that they exist so that if you're dealing with U.S. origin items, even EAR 99 items, and it's going to one of these, 20,000 plus parties, there may be a complete thou shalt not sell to them that U.S. origin item, or there may be a license requirement, and it could be a policy of denial, could be case by case. So it's something to keep in mind. The Commerce list, they have 4 different ones. State Department has the debarred list and the non-proliferation sanctions list. And then Treasury as the specially designated nationals and the OFAC consolidated list. All of these lists, they do update them daily on the website on USA Trade, the consolidated screening list, so you can access it that way. There are many software providers that if you're doing any amount of trade at all, most people have shopped around to look at one of these software providers and integrated it into their to their internal system so they can do kind of their screening very quickly. And it's not just the US now. I guess they maybe started it, but there are other countries now and the UN and others that have added prescribed parties to list as well outside of just the United States. So it's something to keep in mind. It can, change the way you deal with a transaction or a sale depending on that customer. And certainly, I think it's probably easily apparent why it's important to screen transaction against these restricted parties lists. Certainly, the laws follow those commodities, those items, that software. The U.S. has a lot of capabilities and works very closely with cooperating enforcement authorities across EU, Asia, etc., on enforcing these laws. And some of these parties that have gotten on the list have worked hard to get on there because they've been caught intentionally and willfully diverting controlled items to different actors or groups that are certainly difficult, or impossible to approve, to either terrorist organizations that have been identified and agreed to by several different organizations and groups or countries, and or for different types of activities. So ultimately, they exist to protect international security. That's why these trade laws are in place. I do think the one thing to keep in mind too is that these lists are changing all the time. So it's important to have a good integrated software in place and think about, kind of when to screen. And I know there are many that will and think about this internally to your organization. When's the best time to screen and how to do it? Do you have a hybrid screening process, or do you do it just as these orders are coming in the first time? If something's customs built and it's going to take a month or two to actually produce it, a best practice, I know many companies will do not only as the order comes into the sales team, but before it goes out the door, that they're going to screen again because a party may have been added to the list. I actually know of a real example, so it does happen, where in this case, a U.S. company shipped an EAR 99 item to a Chinese customer, and it did not require a license when they shipped it. A year later, under warranty, there was some problem with it, came back to the United States for warranty repair, and they actually wisely checked the screening list before they sent it back. Within those 12 months, that Chinese party was added to the entity list, now requiring a license for all items subject to the Export Administration regulations. They actually applied for the license. Believe it or not, it was denied at first. And then after it was ultimately escalated to higher levels, they ultimately approved it with conditions, but not without a lot of work and a lot of effort on everybody concerned. So it was kind of wise that they did a second screening. So thinking about when to screen is extremely important. And just a quick word on delistings, if you will. In other words, there's a lot of lists out there, but each of those organizations and those agencies I mentioned, Commerce, State, and OFAC, have put into their regulations the method of how you submit a request to be removed from that prescribed list. So there are ways to get off. And the government sometimes could make a mistake. They could have maybe gotten some information wrong, or maybe actions or activities of that particular party were historic, were 2 or 3 years ago, and they haven't done it since, and they weren't aware maybe of that, or there was a bad actor 3 years ago, and ultimately, by the time the U.S. government identified it, was able to add that party to the list, maybe that activity has ceased. So there is the ability, to move forward and request to be removed from that list. That do happen by reading the Federal Register. I see it all the time from OFAC and Commerce as well. So it does happen if you do see that. Just a quick slide. I know we've hit on this enough, so I won't wane on too long about his kind of extraterritorial jurisdiction. But I know, and many, as Harry and I have both mentioned, that can be frustrating and seeming like it's the long arm of the law following it. But those laws do follow the commodities or software, and it is trying to protect. It's a partnership really between industry and government to ensure safe global trade, and that all companies and organizations are abiding by the same sets of rules. And there's a reason why we have them. It is to kind of protect the global community from bad actors and nefarious actions or things that shouldn't happen. I have one slide here, and where I did want to share just historically some of the kind of diversion trends we've seen. And by this, by no means do I mean that the countries below these four that are kind of more stringently controlled from the U.S. government, they have long-standing and existing, commercial ties, legitimate commercial ties with these countries, and that's fine and good because of their geographic location with them or their historic trade relationships with those countries. It's just that in the case of a would-be diverter, if you're going to place a front company, an actor, in a situation where you then want to try to hide and not be identified, it would be very likely and better to, if I'm sending something to Iran, to set up my front company in the United Arab Emirates, which is geographically located so close, and they do have, trade ties between those two countries with items originating from those countries. But if it's a U.S. controlled item, that's where you could see some higher risk jurisdiction or activities between those. So I just wanted to share that kind of with you. And certainly, why should diversion risk concern you? Every company typically has set up some kind of processes when they're looking at sales and looking at customers. Do they pay? Certainly the finance department is going to say, are they up with their billing? But certainly the export control folks, the people that are dealing with the international trade laws, are concerned about, what are the players involved, the activities, what are their uses? Are they legitimate? What kind of information? Do they have a website? What kinds of other activities are they involved in? How long have we worked with them? Are we shipping to a distributor? Is it the exact end user? So diversion risk, certainly there are players that I'm familiar with, and I know my colleague Craig too, from his actions and time as an export control officer, has seen good companies maybe not moving too fast, thinking about sales, and not really doing a very honest or deep dive of their due diligence with new customers or different, more higher risk transactions or destinations involved. So it's something that I think everybody just needs to keep kind of in mind. Diversion red flags. Again, I won't go into each one of these, but we'll share this with you. Certainly, it's important, to understand, the activities when you're looking at different potential customers. What do you know about them? What have they shared? Does it seem consistent with their line of business and what their website says? What's the IP address? Does it correspond to that geographic area or somewhere else? Do they, are they declining usual installation or training? Is the payment, or is it a separated transaction? One party's ordering it, another party's paying for it, and then they're having you ship it to a logistics company that then ultimately send it to somewhere else, where it seems like this is all scattered around. Is it being done intentionally, or does that make sense? So some of these red flags, I think, are helpful to share with your, sales team and your other colleagues in your company, just to be aware of, to keep in mind. And mitigating diversion risk, again, obviously looking for any red flags, making sure all of your company officials are kind of aware what doesn't make sense, and having an internal system to raise those red flags or ask questions of other folks within your organization to make sure, do you need, additional assurances? Do I want to get an end user statement from that party signed by an official from that company that they're going to acknowledge and adhere to any kind of conditions of the export requirements of Turkey or the EU or the US, depending on the origin of those items. So mitigating those diversion risks are important as well. And kind of part and parcel with that is thinking about having a program, and which is often referred to an ICP, or an internal compliance program. And one of the things I'd say from the government expectation, and certainly at least from the US government expectation, is one of the first questions typically that's asked when our agents go out to visit US companies. One of the first questions they ask is, do you have an internal compliance program? Can I see it? Tell me about it. And even our export control officers are interested to see if those companies that they're, and organizations they're meeting with, do they have good systems in place? And really, I would say the government, with everything going on geopolitically that we've seen in the world, I think the expectation as a government, if you don't have one, you ought to be thinking about creating one, or at least brushing it off to make sure, do we need to make any changes or revisions to it? And do we have the appropriate resources in place to ensure that we don't get caught up in a diversion scheme, or don't do a good job of due diligence so we get caught up in this? I did want to share, at least from the U.S. standpoint, here are the elements that the Commerce Department's Bureau of Industry and Security recommends as kind of the effective elements of a good compliance program. And a lot of these are just at the very general level, but it's not unusual that you'll see, and I'd put this chart together, these same kinds of elements are not just from a US-centric standpoint, but the Wassenaar Agreement, all these different countries and organizations have very similar, if you see, kind of elements: training, internal controls as far as processes for classifying items and doing due diligence, doing, yearly audits or routine audits of their whole compliance program, reporting, meaning suspicious reporting activity of red flags internally and then out to authorities as necessary. And then, as you could see, which I think is important, is looking at things from a risk-based, conducting a risk assessment continually across the board. So I think it's important that all of these kind of organizations and countries are highlighting, I think, very similar. In some cases, they use slightly different words, but the building blocks and the foundation of these compliance programs are very, very similar. Quick word about, one size does not fit all. Depending if you're, a lab, a university, a distributor, a logistics company, a manufacturer of certain different types of items, what you do and how you prepare your internal compliance program can certainly be different and should be different. And you need to get input from across the board of your organization, of different components of it, to make sure you don't overkill it or underkill it at the same time, and look at all of these different factors when you do put your internal compliance program together. And kind of just one last slide here, I think, or one slide after this. Some folks do overdo it, and you do want to make sure that people within your organization understand it and can comply with it, and look at where's your highest risk area. And that's why I kind of call it the 4 C's, kind of for, I guess, US alliteration: cataloging what your products and services are that your company offers, and then correlating those to acquisition needs of nefarious actors, would-be nefarious actors, then comparing it to the multilateral regulations, and then to the requirements or priorities of enforcement agencies, to then identify kind of your high risk areas, to make sure that the most resources and the best resources are applied to those highest risk areas, but then across the board, so that you don't over comply and overspend. And to the extent you can make it very specific to different parts of that organization, the better. In other words, if I'm working in human resources, or if I'm working in the sales staff, or the R&D, I have my own job to do. If you can give me a one-pager to say, this is what, Tom, I want you to be aware of as you do your job that is most critical to you in our international trade compliance program, that is obviously much more helpful to make it, I think, adhere to. And then finally, my last slide, but before I turn it over to Craig and you can stop listening to me, is kind of what to expect in 2024, what's coming down the pike. And I think you could kind of hear just from Harry and myself that there's probably going to be an increase in BIS power, especially in the enforcement side. Congress has been very supportive. I've seen their budget for 2024 and 2025. It is a huge increase in the kind of the manpower and the resources, not only in the U.S., but in the placement of export control officers in Finland and Taiwan and Canada and other locations to do activities there as part of the Bureau of Industry and Security. A higher correlation, not only with the U.S. government enforcement organizations like the Justice Department and other enforcement groups, but multilateral. There's a lot of work now between the U.S. enforcement authorities and EU and the Pacific Rim, kind of to ensure a good sharing of information to stay on top of this. If ever I've seen more geometric increases in listings and prescribed parties, just while we were on the phone, I get alerts when there's any change to the Federal Register. There were more additions made just while we were doing this talk with you this evening. There's going to be more visits. There's going to be more administrative cases. Enforcement is certainly ramping up their actions. And I mean, really, without effective enforcement, export controls themselves are somewhat meaningless. If there is no police authority that's occasionally monitoring traffic and speed, et cetera, then people will drive as fast or as crazy as they want. The same in export controls. If there's not adequate resources, those export controls can become meaningless. And I think we've seen several earmark cases like the Seagate $300 million fine and that public shaming that I think we'll probably see more of as we go forward. At that point, let me stop and turn it over to Craig to share some of his experiences in Istanbul and in Turkey in general as an export control officer.
Thank you, John. It was great and quite informative presentation. Craig, I want to turn it to you by asking a question. In your experience, that how did the BIS monitor and enforce the export control regulations in Turkey, and what were the main challenges and the difficulties you have faced?
Yes, great question. So as Tom said, without enforcement, the export controls are really ineffective. So as I said in the beginning, and I'll keep this brief just because we want to allow the audience to ask additional questions if they have any. Yeah, I was posted in Istanbul, Turkey at the U.S. consulate there for 5 years. My primary responsibility as the export control officer was to go out to Turkish companies that imported controlled items from the United States and determine where those items, where they were shipped to, or what they were being used for in Turkey. I will start out by saying that 90% of Turkish companies that I visited all over the country, and I've been to that, I think I've been to more cities in Turkey than a lot of Turks, east to west, north to south. 90% of Turkish companies cooperate and are all doing the right thing. I think on an annual basis, my average unverified or unreliable check was somewhere between 8 to 10% of the companies I visited. So it wasn't very high. But as I explained to a lot of, well, just about every Turkish company I visited, you work or you live in a very interesting and difficult neighborhood, if you will. You're bordered by Syria on the south, and I've been down to the southeast. You're bordered by Iran, you're bordered by Iraq, and then you've got Russia that you don't border, but you've only got a few countries in between you, the Caucasus. So I saw a tremendous, there was an increase in activity in Russia or from Turkey to Russia after the war started in, what was it, when was it, 2022?
Yeah. February 22.
Yeah. So, my job got very busy, and some of the challenges that I had was a lot of new companies opening up in Turkey following the war. And a lot of these new companies were one-person companies or two-person companies importing from the US because most of the time there was no license required to go to Turkey. And then those products were being shipped, many of them through Georgia to Russia. That's what we were seeing a lot of. And getting out there and trying to find these companies and give them an education was obviously a tremendous challenge because there were so many of them just popping up. The recommendation that I made to, I think, every Turkish company that I went to, certainly all the good ones, was that you've got to know your end user. especially now with Russia being a big player. I mean, Iran is still there, Syria is still there, but Russia really became the focus of effort, after the invasion. So knowing your customer, and what I found was a lot of companies just weren't doing the basic due diligence that they needed to do. Um, you know, who is this company? When did they open up? How many people work there? Are they willing to sign an end user certificate? I always told Turkish companies, you can create your own end user certificate, something to cover yourself. It doesn't cost you anything. And yes, you don't have to do it, but why not do it? It puts the person, the end user, puts the pressure on them, to sign this document and to acknowledge that they're not going to send this particular product, let's say, to Iran or Russia. And if they're reluctant to do that, that should raise a red flag, because that's what raised the red flag to me. I think Tom, in one of his previous slides, talked about reluctance of customers. When I called a Turkish company to schedule an appointment, if they refused to meet with me or they were hesitant, that was a red flag for me. There's a reason why they don't want to meet with me. It should be a red flag for you as well. A lot of the red flags that Tom listed on that slide that he had are the same red flags for us enforcement officers, for us cops out there. We look at the same things. So if it's a red flag for us, it should be a red flag for you as well. Companies would often ask me, well, how much due diligence do we need to do? How much of a deep dive do we need to do? That's a very, it's a subjective question, but what I would say to them is at least the bare minimum. If you have a new customer that, let's say, opened up in March of 2022, which was very common in Turkey, March of 2022, a lot of IT companies opened up. If you do a basic Google search or you do a Google Maps search and you find out that that address is a gas station or an empty field next to a gas station, and I'm telling you that because that's a true story, that should raise concerns for you, right? That would be a red flag. So those were some of the challenges that I faced certainly just overall in my 5 years in Turkey, but certainly the last 18 months that I was there, those were the challenges. And it was also trying to get Turkish companies up to speed on the regulations. And that's why we're doing these types of webinars. The one thing I will say about Turkish companies, they loved information. They wanted the information. Whenever we had a AmCham conference or something, or a webinar with State Department or OFAC, Turkish companies, they all showed up. We had a ton of participants. They were eager for information, which was a positive. But because the information is constantly changing and the geopolitics of the world is constantly changing and rules and regulations they were changing almost daily, it was hard for folks like us to keep up. I know how tough it was for Turkish companies to keep up. So the challenge was getting out there and getting the information out to companies as quickly as we could, so that they, didn't do something that they weren't supposed to do. So I'll leave it at that. I'll just finish by saying once again, 90%, maybe even more, 90% of Turkish companies are all doing the right thing. They want to cooperate. They want to help. They don't want to mess up. And so then it's that 8 to 10% that guys like me had to worry about. And they're out there, and they were popping up more so after the invasion. So, and Russia's still a very, very real thing. I know, attention has been diverted recently because of what's been going on in the Middle East, but Russia is still going on. There's still a war happening, and they're still trying to get our stuff. So we need your help. You're on the front lines, as I used to tell you all. You're the ones dealing with the customers. You're talking to them on the phone. You're exchanging emails with them. So, and any questions you have, certainly in Istanbul, you've got the U.S. consulate there. My replacement is there. And then you've got the embassy in Ankara. So I'll leave it there, Tom. So we can open the floor, I suppose, if there are additional questions. If folks want specific examples, I can certainly give you some specific examples of what I saw.
Well, thanks, Craig. And I think your personal, kind of experience in country and is helpful to kind of hear, to add to just, the basic slides that Harry and I have shared, which I think is important because the whole purpose of that is to encourage and ensure legitimate trade between the U.S., Turkey, and other neighboring countries. So hopefully we can continue that and stop the bad ones. We may have answered every question. Thanks for yours, Safik. Are there any other questions? I know we've gone just a little over an hour, but we'll be glad to welcome any. And I just would add as well, if you do have a question or you think of one afterwards, which often it happens, please, send it to Safik and he can get it to us. And we'll be glad to respond, after the webinar, but we certainly do appreciate your attending today, and hopefully it was helpful and interesting and you learned something, and we got a chance to share some time with you too, which we really enjoy. So welcome, and we look forward to doing more webinars with you in the future.
Thank you, Tom.
Absolutely. Thanks, everyone. The
Thank you,
Turkish society has a bright future, and look forward to being a part of it.
And
Take care.
thanks.
Bye-bye.
Thanks. Bye-bye. Thanks.